Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Appears I left the bathroom door open. How rude of me. We have a question here from YouTube user Mijo Tito, who says, "Hello, Mr. Vince. Hello. My employer was hired. Oh, my employer has hired some type of company to respond with a position statement on the charges of disability discrimination that I filed against them. So right off the bat, did you file with the Equal Employment Opportunity Commission or somewhere else? For the purposes of my answer, I'm going to assume the Equal Employment Opportunity Commission, aka the EEOC. All right, because that's what we do here. We answer answer questions about federal laws. In the position statement, on behalf of my employer, and also the company they hired was either a defense law firm or some kind of third-party contractor who does disability discrimination compliance work, but probably it was a law firm, like an employment defense law firm, or a general large law firm that does employment defense work as one of their areas of practice. Going on. In the position statement, on behalf of my employer, they included about 30 pages of the store code of conduct. All nonsense. That has no value. And I never understand why defense counsel really do that. I mean, I guess they're proving that they have policies, which, okay, great. But it's not like a core facet in any of these litigations. It's always kind of meaningless. The other 3 to 5 pages are documents they claim were mailed out to me, which I never responded to. According to them, these documents clear them from the charges of disability discrimination. I know 100% I did not get those papers. I never even heard of that company department. Neither was I able to find information on the web mentioning that department. Those papers are fake. Now what? Okay, so now you write your rebuttal. And I would suggest you check out our Rebuttal Writing 101 video. Ideally, you would have an attorney for this, right? Have you put in a settlement demand? Have you made a demand, like a monetary demand in terms of what you want to settle your case? There's a lot of things to do right now, but the top 3 things that I would hit in rapid succession, your top 3 things on your punch list right now are hire an attorney, get a rebuttal going, watch our Rebuttal Writing 101 video, or have an attorney, and then watch your damages calculation playlist and figure out your demand, or speak with your attorney to figure out your demand. Ideally, you would have an attorney, you'd be speaking with your attorney. Our playlist, which includes the Rebuttal Writing 101 and how to calculate your damages, they're great. They're not nearly as great as having your own counsel who is experienced in this field, and that is not me trying to get you to hire our firm. Ideally, you would hire a local counsel who will help you, and it'll be more economical for you because they don't have to fly attorneys around the country, right? Hire a local counsel. Talk to a local counsel first. Do not hire one of the national firms unless you, for some reason, must. You can't find good representation locally is the best reason, right? Okay, now, what else can I tell you here? I'm trying to think. Those papers are fake, you're saying. Now, that's a big accusation. If you can prove the papers are fake, more power to you. That's amazing. Go ahead, right? Consider, however, that if you take the big swing to prove those papers are fake, and it turns out that department does exist, because it probably does, and it turns out those papers did get generated, because they probably did, or at least they might have, right? Then when you say they're fake, you need a fallback position, at the very least, right? And realistically speaking, you can say, listen, we don't think those documents were ever generated. We don't even think that agency or that department even exists. But to the extent the department does exist, and to the extent they did generate those documents, I never received them. So we need to ask them where they were sending them, if they have proof that they sent them, because I never received those documents. Did they follow up? Did they send me an email after they sent hard copy? Did they call me, right? The burden of the reasonable accommodation dialogue, because you're dealing with an ADA claim, right? You have disability discrimination. So inherent in the Americans with Disabilities Act is the responsibility of the employer to engage in the reasonable accommodation dialogue, right? It might be you were out of work, or maybe you were going back to work and you need accommodations. I don't know. It's not included in your question. But I'll say this. A lot of the burdens in the reasonable accommodation dialogue are on the employer. They're not on you as the employee. So it's easy for them to say, like, oh, we mailed out these 5 things and we never heard back, so we're not at fault. That's an argument. It's not an amazing argument. I would say instead, listen, where did you mail them? Prove you mailed them. We don't think you did, but even if you did, you didn't mail them to the correct place. Music just comes on out of nowhere. And then, why didn't you email? Why didn't you follow up? Why didn't you call? I'm a valued employee. You respect people with disabilities. You want this to work out. You have burdens. You have duties, responsibilities under the Americans with Disabilities Act. Did you comply with those? It doesn't seem like you did. So if your argument is, well, we mailed out 5 documents or whatever it is, and you claim that alleviates all your responsibilities under the ADA, probably not. Probably not a great argument for the defense counsel. That's probably the best argument they had, so you might have a really strong case. I don't know. I'm just saying, sounds like they went a little light. They didn't have perhaps the best arguments at their disposal, so they did what they could, which is good for you. It's good for you. So, assuming you're pending in the EEOC, assuming you are searching for counsel or you already have counsel, the next stage is writing that rebuttal and making a settlement demand. Have you thought about what you want? Have you thought about what the case is worth? Those are 2 different questions. What the case is worth is probably more meaningful to your settlement demand than what you want, but both of those questions matter, right? And that's also something attorneys mess up all the time, right? Like, I'll talk a lot of times with young associates who are like, oh yeah, I had to shut the client down. They wanted all these things that aren't available in the damage calculation. That's not great, right? So like the question isn't, what do you want? Okay, that's the only thing that matters. The question is, what do you want? Okay, I hear you, and we care about that. Now, let's talk about the valuation of the case. Let's talk about what the case is worth, and let's talk about that in the context of what you want, right? You want X, Y, and Z. And in valuing the case, in terms of the leverage we have, we think we can deliver X and Y. We don't think we can deliver Z, at least not in settlement. Maybe not even at trial. So, what do you think about that client? And that's really different than shutting the client down. That's the difference between having an interactive discussion about, like, hey, okay, I hear what you want. You want X, Y, and Z. And I don't believe I'm going to get you that Z. I do believe I can potentially deliver the other 2, the X and the Y. And how do you feel? How do you feel, client, who is the person who is actually wronged here, about the fact that I don't believe I can deliver Z, right? And if you as the client, if your response was, oh, now I want X, Y, and Z and T through V. Okay, so like you're engaging in self-harm, and that's a you problem. The attorney can't, if the attorney can get you X and Y but not Z, or at least that's what the attorney believes, and you're like, well, now I want these other 30 things, or $30 million. Okay, well, this doesn't change the leverage you have, right? By the same token, if the associate's like, hey, I didn't ask you what you wanted. This is what the case is worth. Not good. Not okay. Not how this is done. Not best practices, in my opinion. And I'm just a guy on the internet. That's just not what I think is a good way to go about this. But that's something you need to engage in. You need to have those conversations with your counsel. And if you don't have an attorney, you need to watch damages calculation playlist, or like get down to valuing your claims and figuring out what you want and what you can get out of this case, and realizing those are 2 different questions. Anyways, I hope this is helpful, mijo Tito, and I hope that you get lots of money. I hope you are victorious, that the wrongs are righted, and that you are made whole. If it was helpful, like, subscribe, comment down below, share our channel elsewhere so it can grow. And we're all cheering for you. Go get paid.